Legal disclaimer. The content presented in this video series, including all spoken narration, on-screen text, and accompanying materials, is strictly for educational, informational, and entertainment purposes only. It does not constitute legal advice, professional employment consulting, or a substitute for legal counsel. Employment laws in the United States vary significantly by state, county, and municipality, and are subject to frequent legislative changes and judicial interpretations. While we strive to provide accurate and up-to-date information regarding federal regulations such as the Fair Labor Standards Act (FLSA), the Civil Rights Act of 1964, and guidelines from the Equal Employment Opportunity Commission (EOC), we cannot account for every specific jurisdictional nuance or individual circumstance. No attorney-client relationship is formed by viewing this content. If you are facing a specific legal issue regarding wrongful termination, discrimination, wage theft, or contract disputes, you are strongly advised to consult with a qualified labor and employment attorney licensed in your specific jurisdiction or contact the appropriate state or federal agencies, such as the U.S. Department of Labor. Viewers should conduct their own due diligence before taking any action based on the information provided. We accept no liability for any potential outcomes, losses, or damages resulting from the application of the information discussed in this deep dive masterclass. 74%. That is the percentage of American workers who believe they have protections that simply do not exist. Conversely, there is a multi-billion-dollar deficit in unclaimed wages and settlements every single year because millions of employees walk away from situations where their rights were flagrantly violated, simply because they did not know the specific legal trigger words to use in an email. Imagine this scenario. You have been a top performer for 3 years. You are called into a stark, glass-walled office on a Tuesday morning. Your manager, someone you trusted, refuses to make eye contact. An HR representative you have never met slides a piece of paper across the desk. They tell you your position is being eliminated due to restructuring. They offer you 2 weeks of severance pay if you sign a document right now, a document that waives your right to sue. You feel panicked. You feel powerless. You sign. In that moment, you may have just walked away from a potential 6-figure settlement because you didn't know that the restructuring was statistically targeting workers over the age of 40, a violation of the Age Discrimination in Employment Act. Or perhaps you didn't realize that your dismissal came exactly 3 days after you mentioned a safety concern in the warehouse, making this a potential retaliatory firing under OSHA regulations. This isn't just about losing a job. It is about the systematic asymmetry of information. The company has a legal department. The company has a handbook written to protect them, not you. The company knows the rules. You are playing a game where your livelihood is the wager, and you are playing it blindfolded. This series is going to take that blindfold off. We are about to embark on a comprehensive, forensic examination of the American worker's relationship with the law. This is not a quick tips video. This is not a listicle of 5 things HR hates. This is a masterclass designed to fundamentally alter the power dynamic between you and your employer. By the end of this 10-part deep dive, you will possess a functional working knowledge of the federal and state mechanisms that govern your 9-to-5 existence. We are going to solve the problem of professional vulnerability. Most people navigate their careers operating on myths, rumors, and half-truths they heard from a coworker. They believe that at-will employment means they have 0 rights, which is false. Or they believe that the First Amendment protects their speech in a private office, which is also false. This ignorance is expensive. It costs American families stability, it costs them leverage in salary negotiations, and it costs them dignity in the workplace. The promise of this series is clarity in a system designed to be opaque. We are going to deconstruct the jargon. When we talk about exempt versus non-exempt, we aren't just defining terms. We are going to explore how misclassification is used to steal overtime wages from millions of salaried employees who are given fancy titles like assistant manager, just to avoid paying them time and a half. When we discuss hostile work environment, we will move beyond the buzzwords and look at the strict legal standards required to prove it in court, looking at historical case studies where behavior was toxic, but legal, versus behavior that crossed the line into actionable harassment. We are going to explore the intersection of the Americans with Disabilities Act, ADA, and modern remote work, analyzing how the definition of reasonable accommodation is shifting in real time. Furthermore, this series addresses the modern fragmentation of the workforce. The economy has shifted beneath our feet. The rise of the gig economy, the prevalence of independent contractor agreements, and the erosion of traditional union power have left a vacuum of protection that you must fill with self-education. We will address the 1099 loophole, where employers attempt to bypass payroll taxes and benefits by labeling full-time staff as contractors. We will examine the specific rights of nursing mothers in the workplace, the intricacies of the Family and Medical Leave Act (FMLA), and the often misunderstood laws surrounding discussing your salary with coworkers. Spoiler alert: preventing you from discussing your pay is a federal violation of the National Labor Relations Act. Yet it happens in offices every single day. This is about risk management for your career. We are treating your labor as a business asset. No successful CEO would sign a contract they didn't understand. Yet millions of workers sign offer letters every year without understanding the implications of non-compete clauses, mandatory arbitration agreements, or intellectual property assignments. We are going to read the fine print together. We are going to look at the at-will doctrine, which is the bedrock of U.S. labor law, and we are going to map out the exceptions: the public policy exception, the implied contract exception, and the covenant of good faith. You will learn to distinguish between unfair treatment, which is often legal, and illegal discrimination, which is actionable. We will also tackle the procedural aspect of rights. Having a right is useless if you don't know how to exercise it. We will discuss documentation, the art of the paper trail. You will learn why sending a follow-up email after a verbal conversation is not just good etiquette, but a critical legal strategy. We will talk about the statute of limitations, and how waiting too long to file a complaint with the EEOC can permanently bar you from seeking justice, regardless of how valid your claim is. We will look at the role of the Department of Labor, and how to file a wage claim without a lawyer. This is not about being litigious. It is not about looking for a fight. It is about being anti-fragile. It is about walking into your workplace with the quiet confidence that comes from knowing exactly where the lines are drawn. It is about knowing when to speak up, when to document, and when to seek professional counsel. It is about ensuring that the contract you trade your time for is honored. Over the next 10 segments, we will build this knowledge block by block. We are constructing a fortress of competence around your career. We are moving from the vague anxiety of "can they do that?" to the concrete certainty of "here is what the law says." This is the education that should be mandatory in every high school and college but isn't. Welcome to the masterclass on basic employee rights. Let's get to work. To build this fortress, we must first inspect the foundation. In the United States, that foundation is a legal doctrine known as employment at will. If you take nothing else away from this entire series, you must understand this concept inside and out, because it dictates the terms of engagement for roughly 74% of the American workforce. It is the default setting of the American labor market. Here is the raw, unvarnished definition. In every state except Montana, absent a specific contract stating otherwise, your employment is voluntary and indefinite for both parties. This means you can quit at any time for any reason or for no reason without giving notice. That is the part everyone likes. But the reciprocal reality is that your employer can terminate you at any time, for any reason, good, bad, or indifferent, or for no reason at all, without notice and without a severance package. Let's play out a scenario to make this visceral. Imagine you show up to work on a Friday. You have never been late. Your performance reviews are stellar. You just closed the biggest deal of the quarter. You walk in wearing a purple tie. Your boss looks at you and says, "I hate the color purple. It reminds me of my ex-wife." You're fired. Pack your things. In a just cause system, which exists in many European countries and unionized environments, that firing would be illegal. It is arbitrary, capricious, and unrelated to your job performance. But under the pure at-will doctrine in the United States, that firing is completely legal. The boss does not need to prove you were incompetent. They do not need to prove they are downsizing. "I don't like your tie" is a legally sufficient reason to terminate your livelihood, provided, and this is the massive provided we will dissect, that the reason isn't a cover for illegal discrimination against a protected class. Many employees operate under the fairness fallacy. They believe that if they work hard and follow the rules, the law protects their job. It does not. The law protects your civil rights. It does not protect your employment stability. However, the at-will doctrine is not bulletproof. Over the last century, courts and legislators have carved out 3 major exceptions to this rule. Understanding these exceptions is how you determine if a wrongful termination has actually occurred. The first and most robust exception is the public policy exception. This is the shield that protects you from having to choose between your job and the law. Courts in most states recognize that society has an interest in ensuring citizens can obey the law without fear of destitution. Consider the jury duty scenario. You receive a summons to serve on a jury. Your employer tells you that if you miss work for jury duty, you will be fired. If they follow through with that threat, they have violated public policy. The legal system cannot function if employers are allowed to punish employees for participating in it. This extends to whistleblowing and refusing to commit illegal acts. Let's say you work for a trucking company. Your manager orders you to drive a rig that you know has faulty brakes and violates Department of Transportation safety regulations. You refuse to drive it because it is illegal and dangerous. They fire you for insubordination. Under a strict reading of at will, that looks like a legal firing. But under the public policy exception, this is wrongful termination. You cannot be fired for refusing to break the law. This is a critical distinction. The request must be illegal, not just unethical or uncomfortable. If your boss asks you to lie to a client about a delivery date, that is unethical, but refusing might get you fired legally. If your boss asks you to falsify tax documents, that is illegal, and refusing is protected. The second exception is the implied contract exception. This is where the paperwork you signed, and the paperwork you didn't read closely enough becomes a weapon. Even if you don't have a written employment contract guaranteeing you a job for 5 years, an implied contract can be formed based on employer representations. This often happens through the employee handbook or verbal promises. Imagine your manager is trying to recruit you from a competitor. During the interview they say, "As long as you hit your sales targets, you'll have a job here for life." You take the job. 2 years later, you are hitting your targets, but they fire you anyway to save money. You might have a claim for breach of an implied contract because you relied on that specific promise to your detriment. However, companies have become extremely sophisticated at closing this loophole. This is why, if you look at the first page of almost any modern employee handbook, you will see a bold, capitalized disclaimer stating, "Nothing in this handbook creates a contract of employment." They are explicitly telling you that the progressive discipline policy, where they say they will give you a verbal warning, then a written warning, then a suspension before firing you, is just a guideline, not a promise. If they skip the warnings and fire you immediately, that disclaimer is their legal defense. They are arguing that no contract was ever formed. This is why probationary periods are often misunderstood. People think passing probation grants them security. Usually, it just means you are now eligible for benefits. You are still an at-will employee. The third and rarest exception is the covenant of good faith and fair dealing. This is a complex legal theory recognized in only a handful of states, like California. It essentially prevents employers from acting with malice or bad faith to cheat you out of benefits you have already earned. Let's look at the commission snatch case study. Imagine you are a software salesperson. You work on a massive deal for 6 months. You finally get the client to sign the contract on December 20th. Your commission check for $50,000 is due to be paid on January 15th. On January 2nd, your employer fires you for no stated reason. They then argue that because you weren't employed on the payout date, they don't owe you the commission. In states that recognize the covenant of good faith, a court would likely look at the timing. It appears the employer fired you specifically to avoid paying the commission you had already earned. That is bad faith. The termination might still stand, you don't get the job back, but they would be forced to pay the damages. It is crucial to note the geographic anomaly of Montana. If you are watching this from Montana, the rules are entirely different. After a probationary period, employers in Montana generally need good cause to fire an employee. They are the only state in the union that has statutorily abandoned the at-will presumption. For everyone else from New York to California, at-will is the air you breathe. So why does this matter to you today? Because it dictates your strategy. If you are called into that office to be let go, arguing this isn't fair is a waste of breath. Fairness is not a legal concept in the at-will doctrine. Arguing "I'm a good worker" is irrelevant. To survive or negotiate a settlement, you must frame your situation through the lens of the exceptions. You aren't being fired for no reason. You are being fired in violation of public policy. You aren't being fired for poor performance. You are being fired in breach of the implied promises made in the handbook. But wait, remember the purple shirt scenario? We established that firing someone for a shirt color is legal. But what if the reason wasn't the shirt? What if the purple shirt was just a pretext? What if the real reason the boss fired you was because you are pregnant? Or because you are 55 years old? Or because you just came back from military service? Suddenly, the at-will defense crumbles. This brings us to the most explosive and frequently litigated area of employment law: discrimination and protected classes. This is where the federal government steps in and says, you can fire someone for a bad reason, but you cannot fire them for this reason. The line between a jerk boss and a law-breaking boss is often razor-thin, and it usually comes down to one specific factor: the protected class. Are you in one? You might be surprised to find out that you are. In the next section, we are going to tear apart the Civil Rights Act, the ADA, and the ADEA to identify exactly who is protected, and more importantly, how you prove that the purple shirt excuse is a lie designed to cover up a legal bias. You think you know what discrimination looks like? The data suggests you are likely looking for the wrong signs. Every single person watching this video belongs to multiple protected classes. This is the most common misconception about employment law: the idea that protected class refers only to minorities or specific marginalized groups. It does not. If you have a race, you are in a protected class. If you have a gender, you are in a protected class. If you have a religion or a lack of one, you are in a protected class. The Civil Rights Act of 1964, specifically Title VII, does not create special rights for some. It creates a baseline of equal treatment for all. However, understanding who is protected is easy. The hard part, the part that costs employees millions in lost settlements, is understanding how to prove that protections were violated when the employer is lying to your face. Let's go back to the purple shirt scenario. Your boss claims you were fired for wearing a purple shirt. In a vacuum, that is legal. But in the real world, employment decisions do not happen in a vacuum. They happen in patterns. To uncover discrimination, we have to look for what the courts call pretext. Pretext is the legal term for a false reason given to cover up the real reason. It is the lie that hides the bias. How do you prove pretext? You rarely find a smoking gun. In 2024, very few managers are stupid enough to send an email saying, "Fire John because he is too old," or "Don't promote Sarah because she might get pregnant." Instead, they use coded language. They say John is resistant to change or doesn't fit the new energy of the team. They say Sarah lacks long-term commitment. To strip away this code, you need comparators. A comparator is a coworker who is similarly situated to you. Same job, same supervisor, similar conduct, but who does not share your protected characteristic. If you, a 55-year-old employee, are fired for being 5 minutes late, but your 25-year-old colleague arrives 20 minutes late every day and is only given a high five, you have just identified a comparator. The inconsistency exposes the pretext. The lateness wasn't the reason, the age was. Let's break down the major federal statutes, because each has specific triggers and traps. First, Title VII of the Civil Rights Act. This covers race, color, religion, sex, and national origin. Note that color and race are distinct. Discrimination based on skin tone, lightness or darkness within the same race is actionable color discrimination. Under sex, we now have robust protections for sexual orientation and gender identity, following the Supreme Court's Bostock decision. But look at national origin. This is frequently subtle. It often manifests as English-only rules. Is it legal for a workplace to demand you speak only English? It depends. If it is a business necessity, say for safety communications in a hazardous plant, it might be legal. If it is enforced during your lunch break just because the manager doesn't like the sound of Spanish or Tagalog, that is likely illegal national origin discrimination. Then we have the Pregnancy Discrimination Act, PDA. This is a critical amendment to Title VII. The golden rule here is that pregnancy must be treated like any other temporary disability. If a company allows a man with a broken leg to work light duty, they must allow a pregnant woman with a lifting restriction to work light duty. They cannot force you to take leave if you are capable of doing your job. If your boss says, "Go home and rest, you shouldn't be working in your condition," and you didn't ask to go home, that is not benevolence. That is a potential violation of federal law. Next is the Age Discrimination in Employment Act, ADEA. This law is unique because it is a one-way street. It only protects workers who are 40 years of age or older. If you are 25 and you are fired for being too young and inexperienced, federal law generally does not help you. But if you are 50 and fired for being overqualified, which is often code for too old and expensive, that is actionable. Be warned. The Supreme Court has made ADA cases harder to win than Title VII cases. For age discrimination, you generally have to prove that age was the but-for cause of the firing, meaning if not for your age, you would still have the job. In other discrimination cases, You only have to prove it was a motivating factor. This higher standard means you need tighter evidence for age claims. Watch out for role elimination where your job is cut, and 2 weeks later a 22-year-old junior associate is hired to do your exact duties for half the salary. That is a classic ADA red flag. Then there is the Americans with Disabilities Act, ADA. This acts differently than the others because it requires an interactive process. If you have a disability, which is defined very broadly to include physical and mental impairments that substantially limit a major life activity, you have the right to request a reasonable accommodation. This is where most employees fail. They demand rather than request, or they assume the employer has to give them exactly what they want. The employer does not have to provide your preferred accommodation, only an effective one. If you have back pain and ask for a $2,000 ergonomic chair, they can say no and offer a $50 lumbar support cushion instead, if the cushion allows you to do the job. Furthermore, you must be a qualified individual. This means you can perform the essential functions of the job, with or without accommodation. If you are a warehouse loader and your disability prevents you from lifting more than 10 pounds, and the essential function of the job is lifting 50-pound boxes, the ADA does not save your job. The company does not have to invent a new position for you or eliminate essential duties. However, they must engage in a good faith dialogue to see if a workaround exists. If they fire you immediately upon learning of your disability without that dialogue, they have likely broken the law. Let's clarify harassment, because the internet has distorted this term. Legally, harassment is a form of discrimination, but not all bullying is illegal. If your boss is a tyrant who screams at everyone regardless of race, gender, or age, he is an equal opportunity jerk. Being mean is not illegal. To be actionable, the harassment must be based on a protected class and be severe or pervasive. One off-color joke usually doesn't qualify. A pattern of jokes, slurs, or physical intimidation does. This leads to the hostile work environment. This isn't just a workplace you dislike. It is a workplace where the abuse is so frequent and severe that a reasonable person would find it intolerable. There is also quid pro quo harassment, which is strictly sexual. Sleep with me and you get the raise. This is automatically illegal the moment the offer is made, regardless of whether you accept or reject it. Here is the strategic takeaway for this section. Documentation is your only shield. If you suspect discrimination, you must document it in real time. Write down the dates, the times, the witnesses, and the exact quotes. Most importantly, if you file a complaint with HR, you just triggered another protection, retaliation. Retaliation is the most common finding in EOC cases, more common than the discrimination itself. It is illegal for an employer to punish you for engaging in protected activity, like filing a complaint or participating in an investigation. If you complain about sexual harassment on Monday, and on Tuesday your shift is changed to the graveyard slot, that is retaliation. Often, the original discrimination case might be weak, but the retaliation case is slam dunk strong. Juries hate bullies who punish people for speaking up. However, even if you are in the right protected class, and even if you have evidence of bad behavior, there is a silent killer in the workplace that affects every single employee, from the janitor to the CEO. It is not about who you are, it is about how you are paid. You can be treated with perfect respect and still be robbed blind every pay period without realizing it. There is a massive classification system that determines whether you get paid for your extra time or if you work for free. Millions of Americans are currently in the wrong category, donating hundreds of hours a year to their employers under the false belief that salary means no overtime. In the next part, we are going to expose the exempt versus non-exempt lie and show you how to calculate exactly how much wage theft you might have already suffered. This is the money part. You don't want to miss it. Let's talk about the biggest financial lie sold to the American workforce. It is a lie that costs employees billions of dollars annually. Not in theoretical money, but in cold hard cash that should be in their bank accounts but isn't. The lie is this: if you are on a salary, you are not entitled to overtime pay. This is false. It is dangerously false. And if you believe it, you might be working for free for 10, 20, or 30 hours every single week. To understand how this theft works, we have to look at the Fair Labor Standards Act, FLSA. Passed in 1938, this law established the 40-hour workweek. It created a binary system for every worker in America. You are either non-exempt or you are exempt. Think of non-exempt as the default setting. If you are non-exempt, you are entitled to the minimum wage, and critically, you are entitled to time and a half. 1.5 times your regular rate of pay, for every minute you work over 40 hours in a 7-day workweek. It doesn't matter if you agreed to work late. It doesn't matter if you love your job. If you work 41 hours, you get paid for 41.5 hours. Then there is exempt. This is the exception. If you are exempt, the law says you are distinct. You are paid for the job, not the hour. You can work 30 hours or 80 hours, and your paycheck remains exactly the same. You are exempt from the overtime protections of the FLSA. Here is where the scam happens. Employers love to move people from the non-exempt column to the exempt column. Why? Because it makes labor costs predictable and cheap. If I can pay you a flat salary of $50,000 and work you for 60 hours a week, I am getting 20 hours of labor for free. That is pure profit for the company. So how do they do it? They give you a title. They call you a manager, an administrator, or a director. They hand you a salary offer letter and shake your hand. But here is the secret they hope you never learn. Job titles do not determine your status. Your actual job duties do. To be legally classified as exempt, the employer must prove you pass 3 specific tests. If you fail even one of these tests, you are non-exempt, and they owe you overtime money regardless of what your contract says. First is the salary basis test. You must be paid a predetermined, fixed amount that is not subject to reduction because of variations in the quality or quantity of work. If your boss docks your pay because you left 2 hours early on Tuesday, they have just treated you like an hourly worker. By doing that, they may have forfeited the exemption, meaning you might be retroactively owed overtime for every extra hour you've ever worked. Second is the salary level test. You must be paid above a specific minimum threshold set by the Department of Labor. This number is subject to change and often heavily litigated in federal courts, but the principle is absolute. If you make less than the federal threshold per week, or the state threshold, which can be higher in places like California or New York, you are automatically non-exempt. It doesn't matter if you are the CEO's right-hand man. If the salary is too low, you get overtime. Period. Third, and this is the smoking gun, is the duties test. This is where the assistant manager trap catches millions. Let's look at a case study. Imagine you are hired as an assistant store manager at a fast food franchise or a retail clothing store. You are on a salary. You feel important. But what do you actually do all day? You run the register. You fry the fries. You fold the clothes. You sweep the floor. Maybe for 10% of your day you count the till or lock the door. Under the FLSA executive exemption, to be truly exempt, your primary duty must be managing the enterprise. You must customarily direct the work of 2 or more full-time employees. And this is key, you must have the authority to hire or fire, or your suggestions on hiring and firing must be given particular weight. If you are the assistant manager, but you spend 90% of your time doing the same manual labor as the hourly crew, and you can't fire anyone without asking the district manager first, you are likely misclassified. You are a glorified hourly worker with a fancy title designed to steal your overtime. Let's run the math on this assistant manager scenario to show you the scale of the theft. Suppose you are paid a salary of $52,000 a year. That sounds like $1,000 a week. Not bad, right? You work 50 hours a week. If you were properly classified as hourly, that $52,000 breaks down to about $25 per hour, based on a standard 40-hour week. But because you work 50 hours, you are working 10 hours of overtime every week. Those 10 hours should be paid at time and a half, $37.50 per hour. That is $375 per week in stolen wages. Over a year, that is $19,500 in unpaid labor. By accepting the salary title without checking the duties test, you are effectively donating a brand new car to your employer every single year. The administrative exemption is another common trap. This covers office workers whose primary duty is non-manual work directly related to the management or general business operations. Crucially, it requires the employee to exercise discretion and independent judgment with respect to matters of significance. This is the loophole companies try to use for secretaries, data entry clerks, and junior analysts. If you are just following a manual, if you are just inputting data, if you have to ask for permission to buy a box of printer paper, you are likely not exercising independent judgment on matters of significance. You should probably be getting overtime. Then there is the professional exemption, which applies to learned professionals like doctors, lawyers, engineers, and teachers. This one is harder to fake because it usually requires an advanced degree. You can't call a janitor a sanitation engineer, and use the professional exemption. But wage theft isn't just about misclassification. It also happens in the margins of the clock for those who are hourly. This is the issue of off-the-clock work. The law uses a standard called suffered or permitted to work. If your employer knows you are working, they must pay you. Does your boss text you at 8 p.m. to ask where a file is? That is work. Do you have to put on a specialized uniform or safety gear before you clock in? That donning and doffing time is often compensable work. Do you spend 15 minutes closing out the register after you've already clocked out because labor costs were too high today? That is illegal. There is a concept called de minimis, which essentially means trivial amounts of time. Employers argue that checking one email isn't work, but courts are increasingly siding with employees, especially in the smartphone era. If you are expected to be responsive 24/7, you are working. Look at the tech industry. It is rampant with crunch time. Hourly coders or QA testers are often pressured to eat dinner at their desks and work through unpaid breaks. If you are non-exempt and you are working through lunch and your employer knows it, they owe you that time. Here is the tactical takeaway. Audit your own job. Do not trust the title on your business card. Go to the Department of Labor website and look up Factsheet #17A. Read the duties test for executive, administrative, and professional exemptions. Does your day-to-day reality match the legal description? If you are working 60 hours a week on a salary, but you have zero decision-making power, you are the victim of a very expensive magic trick. But there is a level of deception even deeper than this. What if the company tells you that you don't even work there? What if they say, oh, you aren't an employee at all? You're your own boss. You're an independent contractor. This is the gig economy loophole, the 1099 trap. It is the favorite tool of modern corporations to avoid paying any taxes, any benefits, and any overtime whatsoever. And just like the assistant manager title, just because they call you a contractor doesn't make it true. In the next section, we are going to expose the independent contractor scam. We will show you the economic realities test that courts use to rip up those contracts, and why that freedom they promised you might actually be a prison of liability. You might be owed years of back taxes and benefits and you don't even know it. If you are holding a contractor agreement in your hand right now, there is a statistical probability that the paper you are holding is a legal fiction. In the modern American economy, the line between employee and independent contractor has been deliberately blurred by companies looking to shed liability. This is the 1099 loophole, and it is one of the most pervasive regulatory battles happening in the United States today. Let's define the stakes. When a company hires you as a W-2 employee, they are legally required to pay half of your Social Security and Medicare taxes, contribute to unemployment insurance, carry workers' compensation insurance, and often provide health benefits or 401k matches. It is expensive. When they hire you as a 1099 independent contractor, they pay zero payroll taxes. They pay zero unemployment. They provide zero benefits. They shift the entire burden of running a business onto you. For a company, flipping that switch can instantly cut labor costs by 20% to 30%. That is a massive financial incentive to cheat. But here is the reality check. You cannot simply agree to be a contractor. It is not a choice you and your boss make over coffee. It is a legal status determined by the facts of your working relationship. Even if you signed a contract that says, I am an independent contractor, in bold, red letters, the IRS and the Department of Labor can look at that contract, tear it up and say, no, this is an employee. How do they decide? They use the economic realities test, and sometimes the common law control test. It boils down to one word, control. Imagine this scenario. You are a graphic designer. A marketing firm hires you. They hand you a 1099. They tell you, welcome to the team, you're your own boss. But then they tell you to be at the office at 9 a.m. every day. They provide you with a company laptop and company software. They tell you exactly how to design the logo step by step. They forbid you from taking on other clients. They pay you a set hourly wage, not a per project fee. In this scenario, you are not an independent business owner. You are an employee who is being ripped off. A true independent contractor is in business for themselves. They set their own hours. They use their own tools. They decide how to do the work. The client only cares about the result. They have the opportunity for profit or loss. If you can't make a profit by working more efficiently, and you can't lose money on a bad bid, you probably aren't a business owner. You are a misclassified employee. Let's look at the Uber/Lyft paradigm because this is where the war is being fought. For years, gig economy platforms argued their drivers were contractors because they could log on whenever they want. But recently, states like California with AB 5 and the Federal Department of Labor have tightened the screws. They are looking at whether the work performed is integral to the employer's business. Think about it. Can a ride-sharing company exist without drivers? No, the drivers are the business. If the work you do is the core product the company sells, it is very hard for them to argue you are just an outside contractor. A plumber fixing a toilet at a law firm is a contractor. The lawyers are employees. But a plumber working for a plumbing company? That's likely an employee. Why does this matter to you? Because of the tax bomb. As a 1099 contractor, you are responsible for the self-employment tax, an extra 15.3% on your earnings to cover the Social Security and Medicare portions that the employer would have paid. Imagine you take a contract job for $50,000. You think it's the same as a $50,000 salary. Come April 15th, you realize you owe the IRS $7,000 more than you expected, plus you have no health insurance, and if they fire you tomorrow, you get 0 unemployment benefits. If you suspect you are misclassified, you can file Form SS-8 with the IRS. This triggers an investigation. The IRS will send a questionnaire to your employer asking, who sets the hours? Who provides the tools? If the IRS determines you are actually an employee, the employer can be on the hook for back taxes, penalties, and interest. It is a nuclear option, but it is your right. Now let's pivot to the physical reality of the workplace. We've talked about money, but what about your body? What happens when the workplace itself is dangerous? This brings us to OSHA, the Occupational Safety and Health Administration. Many office workers tune out when they hear OSHA. They think, I don't work in a coal mine or a steel mill. This doesn't apply to me. That is a dangerous assumption. The OSHA Act of 1970 covers almost all private sector employees. It is built on the General Duty Clause, which states that employers must provide a workplace free from recognized hazards that are causing or are likely to cause death or serious physical harm. This definition is evolving. In the 1970s, a hazard was a spinning saw blade without a guard. Today, a hazard might be repetitive strain injury (RSI) from a poorly designed workstation. It might be black mold in the air ducts. It might be workplace violence. Let's look at the right to refuse dangerous work. This is a very specific, high-stakes right. You cannot just walk off the job because you feel unsafe. The legal bar is high. To be protected from being fired for refusing work, generally 4 conditions must be met. You have a reasonable belief that there is a real danger of death or serious injury. You have asked the employer to fix it, and they refused. The urgency of the situation means you don't have time to call OSHA inspectors. There is no other reasonable alternative. Case study. A construction worker is told to go up on a scaffold that is swaying in high winds and missing guardrails. He asks the foreman to secure it. The foreman says, "Do it or go home." The worker refuses. If the worker is fired, OSHA can sue the employer to get the worker their job back with back pay. But be careful. If you refuse work because the office is too cold or the chair is uncomfortable, that is not an imminent danger of death or serious physical harm. You can likely be fired for that. And then there is the right to know. Under OSHA's Hazard Communication Standard, you have the right to know what chemicals you are being exposed to. If you are a janitor using industrial cleaners or a hairstylist using chemical treatments, your employer must provide you with safety data sheets, SDS. If they hide that information, they are breaking federal law. But here is the darkest part of the safety conversation. What happens when you are injured? This leads us to the workers' compensation grand bargain. This is a trade-off that was made over a century ago. In exchange for guaranteed medical coverage and a portion of lost wages if you get hurt on the job, you generally give up your right to sue your employer. If you slip on a wet floor at work and break your back, you get workers' comp. You usually cannot sue the company for millions in a negligence lawsuit, even if it was their fault the floor was wet. Workers' comp is an exclusive remedy. However, there are exceptions. If the employer's conduct was intentional, if they physically assaulted you, or if they knowingly removed a safety guard to speed up production, you might be able to pierce that shield and sue for regular damages. The system is designed to get you back to work quickly, often too quickly. Insurance adjusters are not your friends. Their goal is to minimize the payout. They will send private investigators to film you carrying groceries to prove you aren't really injured. They will send you to their doctors who might downplay your symptoms. Knowing that you have the right to a second opinion depending on state laws, And the right to an attorney in these hearings is critical. We have covered your identity, discrimination, your money, wages, and your safety, OSHA. But what about your time? Specifically, the time you need when life falls apart? What happens when you have a baby? Or when you get cancer? Or when your parent has a stroke? Most people assume, I can just take sick days. But sick days run out. This is where the Family and Medical Leave Act, FMLA, comes in. It is the only federal law that guarantees you time off to care for yourself or your family. But here is the catch. It is unpaid. And roughly 40% of the workforce isn't even eligible for it. Do you know if you are in the lucky 60%? Do you know the 1,250-hour rule? Because if you assume you have FMLA protection and you don't, taking that leave to care for your sick mother could legally cost you your job. In the next section, we are going to dissect the FMLA. We will calculate your eligibility down to the hour, and we will look at the confusing patchwork map of paid family leave that only exists in a few specific states. If you plan on ever getting sick or having a family, this next part is mandatory viewing. Imagine a scenario that plays out in HR offices every single day. You are sitting across from your boss. You look tired because you haven't slept in 3 weeks. Your spouse was just diagnosed with stage 4 lymphoma. The treatment plan is aggressive. Chemotherapy every Thursday, radiation every Monday. You need to be there. You need to drive them to appointments. You need to hold their hand when the nausea hits. You tell your boss, I need to take Tuesdays and Thursdays off for the next 4 months. Your boss looks at you, sighs, and says, we really support you, but we can't run a business with a part-time manager. If you can't be here full-time, we have to let you go. In that moment, your entire financial life hangs on one acronym. FMLA. The Family and Medical Leave Act of 1993 is the only federal safety net preventing you from being fired for getting sick or caring for a sick family member. But it is a safety net full of holes. If you fall through one of these holes, you hit the concrete. Let's define exactly what FMLA offers. It provides up to 12 weeks of unpaid, job-protected leave per 12-month period. Note the emphasis on unpaid. The federal government protects your job, not your paycheck. Unless you have accrued vacation time, sick days, or disability insurance, you are going months without income. But the law ensures that when you return, your job, or a nearly identical one, is waiting for you. However, the eligibility gauntlet is where most people fail. You do not get FMLA just because you are an employee. You must pass 3 strict tests. First, the 12 months test. You must have worked for the employer for at least 12 months. These months do not need to be consecutive. If you worked there in 2019, quit, and came back in 2023, that prior time can often count toward the 12 months, provided the gap wasn't longer than 7 years. Second, the 1,250 hours test. This is the silent killer of claims. In the 12 months immediately preceding your leave, you must have physically worked 1,250 hours. Vacation time, paid holidays, and sick leave do not count toward this number. You have to be but in seat working. Let's do the math. 1,250 hours divided by 52 weeks is roughly 24 hours a week. Consider the case of the just-missed part-timer. Imagine a mother who works 23 hours a week so she can pick her kids up from school. She has been loyal to the company for 10 years. She gets sick. She applies for FMLA. 23 hours x 52 weeks equals 1,196 hours. She is 54 hours short. Because of those missing 54 hours, she has 0 federal job protection. Her employer can legally fire her the day she goes into surgery. This is a binary switch. There is no close enough in federal law. Third, the 50-75 rule. This is the geographic trap. Your employer must have at least 50 employees within a 75-mile radius of your worksite. If you work for a small boutique with 15 employees, you have no FMLA protection. But here is where it gets tricky for the modern remote worker. If you work from your home office in rural Wyoming, but you report to a headquarters in Chicago that has 500 employees, does the 75-mile rule apply to your house or the HQ? According to the Department of Labor, for remote workers, your worksite is the office you report to or receive assignments from. So, even if you are the only employee in Wyoming, if the Chicago HQ meets the 50-75 test, you are eligible. Many HR departments get this wrong. They will tell you that because you are alone in Wyoming, you don't qualify. They are incorrect. Now let's look at the intermittent leave superpower. Most people think FMLA means you disappear for 12 weeks and then come back. But life rarely happens in 12-week blocks. FMLA allows for intermittent leave when medically necessary. This means you can take leave in blocks of time, hours, days, or weeks. If you have severe migraines that flare up unpredictably twice a month, you can use FMLA to protect those specific days. If you need to leave at 2 p.m. every Tuesday for physical therapy, that is FMLA. Your employer cannot force you to take the whole day off if you only need 2 hours, provided their payroll system can track hourly increments. This turns FMLA from a blunt instrument into a surgical tool for managing chronic conditions like diabetes, lupus, or depression. But what happens when you return? The law says you must be restored to the same or equivalent position. This does not mean the exact same desk. It does not mean the exact same clients. It means the same pay, the same benefits, and substantially similar duties. Imagine you are a sales director for the Northeast region. You take 12 weeks of FMLA. When you return, they tell you, "We filled the Northeast role. You are now the sales director for the Southwest region." Is the base pay the same? Yes. Is the commission structure the same? Yes. Is the prestige the same? Yes. Then this is likely legal even if you hate the Southwest territory. However, if they bring you back as a sales associate with a lower base salary and remove your ability to earn bonuses, that is an FMLA interference violation. There is one dangerous exception you must know: the key employee exemption. If you are among the highest paid 10% of all employees within 75 miles of the worksite, the company can deny your reinstatement, not the leave itself but the right to come back, if bringing you back would cause substantial and grievous economic injury to the operations. They have to notify you of this status before or immediately after you request leave. If they fail to warn you that you are a key employee, they lose the right to use this defense. If you are a high earner, always ask HR, "Am I classified as a key employee for FMLA purposes?" Get the answer in writing. While the federal law is unpaid, we are seeing a revolution at the state level. We currently have a patchwork map of paid family leave, PFL. If you live in California, New York, New Jersey, Rhode Island, Washington, Massachusetts, Connecticut, Oregon, or Colorado, you live in a different reality than the rest of the country. In these states, state-run insurance programs provide a percentage of your wages, often 60% to 90%, capped at a limit, while you are on leave. This is not money from your employer. It is usually funded by payroll taxes you have been paying for years. If you are in one of these states, do not let your employer tell you, "We don't offer paid maternity leave." The company might not, but the state does. You need to file a claim with the state EDD or Labor Department, not just your HR rep. A critical warning on forced PTO. Many employees are shocked when they request FMLA and their boss says, "Okay, but we are going to use up your 2 weeks of vacation time first." Is that legal? Yes. Under federal law, an employer can require you to substitute accrued paid leave, vacation/sick, for unpaid FMLA leave. Basically, the FMLA clock, 12 weeks, and your vacation clock, 2 weeks, run concurrently. You don't get 12 weeks plus 2 weeks. You get 12 weeks total, and the first 2 are paid via your vacation accrual. The remaining 10 are unpaid. It feels unfair, like they are burning your vacation, but it is standard corporate policy and fully legal under the statute. Finally, we have to talk about the paperwork. FMLA is not automatic. You cannot just text your boss, "I'm sick," and expect protection. You must provide sufficient notice. If the need is foreseeable, like a scheduled surgery or a pregnancy, you generally must give 30 days notice. If it is an emergency, a car accident, a heart attack, you must give notice as soon as practicable, usually within 1 to 2 business days. Then the employer has 5 business days to give you an eligibility notice. You then have 15 calendar days to return the medical certification from your doctor. Do not miss this 15-day deadline. If you are late with the paperwork, your leave can be denied, and your absences can be marked as unexcused. If you accumulate enough unexcused absences, you can be fired for job abandonment. This brings us to a terrifying intersection. To get this leave, you have to prove you are sick. That means sharing medical details. But how much do you have to share? Does your boss have the right to know your specific diagnosis? Can they call your doctor directly and ask, "Is he really that sick?" Can they demand to see your therapy notes or your cancer prognosis? We are entering the world of privacy rights. Most people think HIPAA prevents their boss from asking medical questions. Spoiler alert: HIPAA applies to doctors and insurance companies, not your boss. Your employer can ask for medical information, But there are strict, ironclad limits on what they can ask and where they can keep that file. In the next section, we are going to expose the medical privacy myth. We will explain exactly what your boss is allowed to see, what is illegal for them to ask, and the genetic information trap that could land a company in federal court. If you value your privacy, you need to know where the line is drawn. There is a phrase that gets thrown around in office disputes like a grenade. That's a HIPAA violation. You hear it when a boss asks for a doctor's note. You hear it when HR asks why you need crutches. And almost every single time you hear it used in a workplace context, it is wrong. Let's shatter the biggest myth in medical privacy right now. The Health Insurance Portability and Accountability Act, or HIPAA, applies to healthcare providers, insurance companies, and clearinghouses. It prevents your doctor from tweeting about your surgery. It prevents your insurance company from selling your records to a tabloid. It does not prevent your boss from asking you, "Do you have COVID?" Or, "When will your broken leg heal?" Your manager is not a covered entity under HIPAA. When you hand that doctor's note to HR, it is no longer protected by HIPAA. It is now an employment record. However, just because HIPAA doesn't apply, doesn't mean they can broadcast your medical history to the entire company. The protection you are actually looking for comes from the Americans with Disabilities Act (ADA), and it is much stricter than most employers realize. The ADA mandates the confidentiality requirement. This is a physical and digital firewall. The law requires that any medical information an employer obtains, whether it is a doctor's note, a drug test result, or a request for a special chair, must be kept on separate forms and in separate medical files from your regular personnel file. Imagine a manager wants to review your performance evaluations to decide if you get a raise. They pull your personnel file. If they open that folder and a note falls out from your oncologist detailing your chemotherapy schedule, the company has just broken federal law. Your medical data cannot be mixed with your disciplinary records or performance stats. It must be locked away, accessible only to those with a strict need to know, such as safety personnel who need to know how to evacuate you in a fire, or supervisors who need to know your specific work restrictions, not your diagnosis, just your restrictions. This leads to the water cooler trap. Let's say you have a chronic condition, maybe Crohn's disease. You trust your manager, so you tell them over lunch. 2 days later, you walk into the break room and a coworker says, "Hey, I heard about your stomach issues, that sucks." Your face goes red. You feel exposed. Is this illegal? It depends on why the manager knew. If you voluntarily disclosed it in casual conversation, the legal waters are murky. But if you disclosed it as part of a formal request for medical leave or accommodation, that information is legally confidential. A manager gossiping about an employee's protected medical condition is not just bad leadership. It creates a hostile work environment based on disability, and it is actionable liability for the company. Now let's look at the genetic information trap. This is the frontier of privacy law. In 2008, Congress passed GINA, the Genetic Information Non-Discrimination Act. It sounds like science fiction, but it addresses a very modern problem. Employers trying to predict your future healthcare costs. GINA makes it illegal for an employer to request, require, or purchase genetic information about you or your family members. It also makes it illegal to use that info for hiring, firing, or promotions. Here is the common GINA violation that happens in casual conversation. A boss asks, "Does breast cancer run in your family?" It sounds like concern. But if you say yes, you have just given them reason to believe you might be an expensive insurance liability in 5 years. That question is illegal. This gets even stickier with wellness programs. You know those company initiatives where they say, "Fill out this health survey and get $50 off your insurance premium"? Be very careful. If that survey asks about your family medical history, did your parents have diabetes? Did your siblings have heart disease? And they tie a financial reward to providing that answer, they are walking a razor-thin line of legality. Under current EOC guidance, the voluntariness of these programs is heavily scrutinized. If you feel coerced to give up your genetic privacy to afford your healthcare, that is a red flag. Let's talk about the doctor call. Can your boss call your doctor directly? This is a terrifying thought. You submit a note saying you need 2 weeks off for stress. Your boss doesn't believe you. Can they pick up the phone, call Dr. Smith and ask, "Is he really stressed? What exactly did he say?" Under the FMLA, the answer is generally no, the direct supervisor cannot call. The law recognizes that a boss calling a doctor is a form of intimidation. However, A human resources professional or a third-party leave administrator can contact your doctor, but only for two specific purposes: authentication and clarification. Authentication means simply asking, "Did you sign this note?" Clarification means asking, "We can't read your handwriting," or "Does light duty mean he can lift 10 pounds or 0 pounds?" They generally cannot ask for your medical charts, your therapy transcripts, or the intimate details of your condition without your specific written consent. If your direct manager calls your doctor and demands to know your diagnosis, that is a massive overstep that should be documented immediately. Then there is the issue of drug testing. In the US, drug testing is largely legal, but there is a prescription safe harbor. Imagine you take Adderall for ADHD. You take a random drug test at work. You test positive for amphetamines. The medical review officer, MRO, calls you. This is the critical moment. You provide your valid prescription to the MRO. Once they verify it, the result is reported to your employer as a negative. The employer does not get to know you are on Adderall. They just get a pass. However, if you are in a safety-sensitive position, like a pilot, a forklift driver, or a surgeon, the MRO might have a duty to report a safety concern if the medication impairs your ability to work safely. But for a desk job, your medication list is none of your boss's business. This entire ecosystem of medical privacy is designed to protect your body. But what about your digital body? We live our lives on screens. We send emails, we type in Slack channels, we browse the web on company Wi-Fi. Most employees operate under a digital illusion of privacy. You think because you have a password, you are safe. You think because you are on your personal Gmail account but using the company laptop that your emails are private. Here is the cold reality. In the eyes of the law, when you are on their equipment, you have almost zero expectation of privacy. But how far does it go? Can they read your private Slack DMs where you complain about the boss? Can they track your keystrokes to see if you are really working or just moving the mouse? Can they turn on your webcam without you knowing to monitor productivity? The technology exists, the software is cheap, and the laws protecting you against digital surveillance are decades behind the tech. In the next section, we are going to expose the digital panopticon. We will look at the legal status of tattleware, the software tracking your every click. We will answer the question: if you use your personal phone for work calls, does the company have the right to wipe your entire photo album if you quit? The answer will make you want to buy a burner phone today. We are moving from biological privacy to digital survival. Do not log into your work email until you watch Part 8. Welcome to the digital panopticon. In the 18th century, philosopher Jeremy Bentham designed a prison called the panopticon where a single guard could watch every inmate without the inmates knowing if they were being watched at any given moment. Today, you voluntarily walk into this prison every time you open your laptop. The single most dangerous assumption modern employees make is believing that password protected means private. It does not. Let's establish the baseline rule of digital employment law. Generally speaking, in the United States, if the device belongs to the employer, or if the network belongs to the employer, you have zero reasonable expectation of privacy. None. Think about that personal folder you created on your desktop. You put your tax returns in there. You put your resume in there. You put photos of your kids in there. You think because you named it personal, the IT department can't look inside? In the eyes of the courts, that folder is akin to leaving a diary open on your desk in the middle of a busy lobby. By placing personal data on company property, you have effectively consented to a search. The legal framework here is the Electronic Communications Privacy Act, ECPA, of 1986. While this law generally prohibits intercepting communications, it has a massive cutout called the business purpose exception. This exception allows employers to monitor oral and electronic communications if they have a legitimate business reason. Ensuring productivity? Legitimate reason. Preventing sexual harassment? Legitimate reason. Protecting trade secrets? Legitimate reason. This loophole is so wide you could drive a server farm through it. We need to talk about bossware or tattleware. This is the productivity tracking software that exploded in usage during the remote work boom. Software like Hubstaff, ActiveTrack, or TerraMind. These programs do not just track when you log in. They can take randomized screenshots of your desktop every 10 minutes. They can log your keystrokes. They can track your mouse movements. Some even use sentiment analysis to scan your emails for negative keywords about the company. Is this legal? In almost all states, yes. Some states, like Delaware and Connecticut, have passed laws requiring employers to notify you that you are being monitored. But notice is not permission, it is just a warning. If they tell you, "We track your keystrokes," and you keep working there, you have consented. Now let's look at the mouse mover arms race. Employees are buying jigglers, physical devices that move the mouse to simulate activity. If you get caught using one of these, it is not just a performance issue. It is often classified as time theft or fraud. Case studies have shown employees being fired for cause, meaning no unemployment benefits, because digital forensics proved their mouse moved in a perfect geometric pattern for 8 hours while they were actually at the beach. The digital footprint you leave behind is permanent and searchable. But the real danger zone is not the company laptop. It is the phone in your pocket. Welcome to the BYOD, bring your own device trap. Companies love BYOD policies because they save money on hardware. They say, just use your iPhone, and we'll give you a $50 stipend. To access the company email or Slack on your personal phone, you often have to install a profile or an app managed by MDM, mobile device management software. When you click install, you are often granting the company remote wipe capabilities. Imagine this scenario. You have worked for a company for 5 years. You have 5,000 photos of your children, your wedding, and your vacations on your phone. You have not backed them up to the cloud because you ran out of storage space. You get fired. Or maybe you just quit to go to a competitor. The IT department hits a button to secure company data. They issue a remote wipe command to remove the company email. But depending on how the MDM was set up and how the command was executed, it might not just wipe the Outlook app. It might factory reset the entire device. Poof! 5 years of memories gone in a millisecond. Is it legal? If you signed the BYOD agreement that authorized remote wiping to protect security, yes. You signed away your digital life for a $50 monthly stipend. The tactical advice here is non-negotiable. Never, ever, under any circumstances, allow an MDM profile on your primary personal device. If they want you to check email, they can buy you a phone. If they refuse, buy a cheap burner smartphone strictly for work apps and keep your personal life physically air-gapped. There is another catastrophic mistake people make with company email: the attorney-client privilege waiver. You are having a dispute with your boss. You decide to sue. You hire a lawyer. You email that lawyer from your work email account, name@company.com. You ask, "Can I sue them for discrimination?" You just destroyed your attorney-client privilege. Because you use company assets to send the message, and because the company handbook says you have no expectation of privacy, courts have frequently ruled that the email is not confidential. The company lawyers can read it. They can use it against you. They can see your entire legal strategy before you even file the paperwork. Always use a private, personal account on a private, personal device for any communication regarding legal disputes with your employer. However, the internet is not entirely a trap. There is one specific area of online speech where you actually have more power than you think. This is the social media loophole, provided by the National Labor Relations Board, NLRB. Many employees believe, if I trash my boss on Facebook, I can be fired. That is true if you are just griping. But if you are organizing, you are protected. This is the distinction between personal grievance and protected concerted activity. Scenario A: you post on Twitter, "My boss Bob is an idiot and I hate this job." Result: unprotected. You can be fired for being unprofessional/disloyal. Bob is a jerk, but that is a personal beef. Scenario B: you post on Twitter, "My boss Bob is making us work through lunch again without pay. Is anyone else on the shift dealing with this? We need to do something." Result: likely protected. Why? Because you are discussing terms and conditions of employment, and you are seeking to initiate group action. You are not just complaining. You are attempting to improve the workplace for everyone. Under the National Labor Relations Act, NLRA, which covers most private sector employees, union or non-union, you have the right to discuss wages, hours, and working conditions. If your company has a social media policy that says, employees may never discuss the company negatively online, that policy itself might be illegal. The NLRB has routinely struck down overly broad social media policies that would chill workers from organizing. But be careful. The line is thin. If your post includes lies, threats of violence, or reveals trade secrets, you lose the protection. But if it is a truthful discussion about salary or safety, you have federal cover. We have covered the surveillance of your actions and the ownership of your data. But there is a more insidious way companies own you. They don't just want your time, they want your future. They want to ensure that if you leave, you cannot work anywhere else. They want to ensure that the brilliant idea you had in the shower belongs to them, not you. This is the world of restrictive covenants.
Non compete agreements. Non-solicitation clauses.
Intellectual property assignments. These are the golden handcuffs, or sometimes rusty iron handcuffs, that keep you trapped in a job you hate because you are terrified you won't be allowed to earn a living in your chosen field for 2 years if you quit. The Federal Trade Commission, FTC, has recently declared war on non-competes, but the battle is messy and millions of workers are still signing contracts that claim to own their careers. In the next section, we are going to dissect the non-compete. We will look at the seismic shift happening right now in federal law, and we will decode the invention assignment clause that could mean your side hustle actually belongs to your boss. You might be building $1 million startup in your garage, but if you sign the wrong paper on day one, you might just be building it for them. Imagine you are a sandwich maker. You spread mustard, stack turkey, and slice bread. You make $14 an hour. You decide to quit and work for a deli across the street for $15 an hour. But 2 days later, you receive a cease and desist letter from a corporate law firm. They threaten to sue you for irreparable harm because you signed a non-compete agreement on your first day. They claim you possess proprietary sandwich assembly knowledge and are barred from working in the food industry within a 5-mile radius for 2 years. This sounds like a dystopian satire, but for years, it was a literal reality for thousands of fast food workers in the United States. While the sandwich case became a public relations disaster that forced change in that specific industry, the underlying legal mechanism, the non-compete clause, remains one of the most powerful and restrictive tools in the corporate arsenal. Roughly 30 million American workers, or 1 in 5, are currently bound by a contract that limits their freedom to change jobs. A non-compete agreement is essentially a contract where you agree not to work for a competitor or start a competing business for a specific period after your employment ends. Employers argue this protects trade secrets and training investments. Critics argue it suppresses wages by killing labor market competition. The landscape of non-competes is currently in the middle of a seismic, chaotic shift. In 2024, the Federal Trade Commission, FTC, moved to ban nearly all non-competes nationwide, arguing they violate antitrust laws. However, this ban has faced immediate, ferocious legal challenges in federal courts. As of right now, we are in a state of legal limbo. Depending on the specific week and the specific judge ruling, the federal ban might be on hold. This means you cannot rely on a headline you saw on Twitter saying, "Non-competes are illegal." For the vast majority of workers today, state law still reigns supreme, and state law is a patchwork quilt of traps. If you live in California, North Dakota, Oklahoma, or Minnesota, you are largely safe. These states have historically strong public policies voiding non-competes. In California, they are virtually unenforceable against employees. In fact, California law goes a step further. If an employer tries to enforce an illegal non-compete against a California employee, the employee can sue them for damages. This is why Silicon Valley thrives. Engineers can leave Google on Friday and start a rival AI company on Monday without being sued into oblivion. But if you live in Florida or Texas, the courts are much friendlier to employers. In these jurisdictions, a non-compete is enforceable if it is deemed reasonable. This word, reasonable, is where the lawsuits happen. Courts look at 3 factors: duration, geography, and scope. Duration. Is a 6-month ban reasonable? Usually yes. Is a 5-year ban reasonable? Almost certainly not. The sweet spot for enforceability is typically 1 to 2 years. Geography. Is a ban within 10 miles of the office reasonable? Likely. Is a ban covering the entire United States? Usually unreasonable, unless you are a C-level executive with national clients. Scope. This is the job function. If you are a software engineer, can they ban you from working as a janitor at a tech company? No. The restriction must be relevant to the work you actually did. Here is the danger of the blue pencil doctrine. In some pro-employer states, if a company writes a terrible, overly broad non-compete, e.g., you cannot work anywhere in the world for 10 years, the judge will not throw it out. Instead, the judge will pull out a blue pencil and rewrite the contract to make it legal, changing it to 10 miles for 1 year, and then enforce it. You lose anyway. In other states like Georgia, post-2011, this rewriting is allowed. In states with strict red pencil rules, if one part of the clause is illegal, the whole thing is thrown in the trash. Knowing which color pencil your state judge holds is critical. Now let's talk about the side hustle trap, technically known as the invention assignment agreement. When you start a job, you sign a stack of papers. One of them says that anything you create during the period of employment belongs to the company. You might think, well, I work 9 to 5. What I do at 8 p.m. in my garage is mine. Not necessarily. If your side project relates to the employer's current or demonstrably anticipated business, or if you used any company resources, they own it. Company resources is a trapwire. Did you write one line of code for your startup on the company laptop? They own it. Did you email a potential co-founder from your work email? They own it. Did you use the company Wi-Fi during your lunch break to research a patent? They might own it. Let's look at the trailer clause or holdover clause. This is the horror story of intellectual property. Some contracts state that if you file a patent within 1 year after leaving the company, there is a presumption that the invention belongs to the former employer. They are assuming you stole the idea from them before you quit. You effectively have to prove a negative that you didn't think of it while working there to keep your own invention. To protect yourself, you need to look for the Exhibit A, or prior inventions, list on your employment contract. When you are hired, there is usually a blank page where you can list inventions you already own. If you are working on a novel, a software app, or a new design, list it there. Describe it. If you leave that page blank, you are legally stating you brought nothing with you, implying anything you produce later was made there. If you are already employed and working on a side hustle, investigate if your state has protections like California Labor Code Section 2870. This law specifically states that invention assignments cannot apply to inventions developed entirely on the employee's own time, without using the employer's equipment, supplies, facilities, or trade secret information, unless they relate to the employer's business. That "unless" is the kicker. If you work for a video game company, and you build a video game at home, they likely own it. If you work for a video game company and you build a new type of toaster at home, the toaster is likely yours. Finally, we have to address the cousin of the non-compete, the non-solicitation agreement. Even if a court throws out your non-compete, the non-solicit often survives. This prevents you from soliciting clients or coworkers. The client poaching ban is standard. You can't leave and immediately call your old book of business. But the rating ban prevents you from hiring your old team. If you leave to start a startup, and you recruit your 3 best friends from your old job, you might be sued for tortious interference. The key word is solicit. If they call you asking for a job, that is generally legal. If you call them, it is a violation. This is why when executives leave, they often go radio silent for a year. They are waiting for the phone to ring so they can say, "I didn't ask them to come, they followed me." We are nearing the end of our journey. We have built the fortress. We know the hiring laws, the discrimination traps, the wage theft scams, the privacy invasions, and the contract handcuffs. But eventually, despite all your preparation, the end comes. Maybe you are fired. Maybe you are laid off. Maybe you just can't take it anymore. This is the most dangerous moment of the employment life cycle, the exit. Most people sign the separation agreement immediately because they are desperate for the severance check. They see 3 months' pay, and they sign away their right to sue for millions in unpaid overtime or discrimination. They don't realize that severance is not a gift. It is a purchase. They are buying your silence and your safety. And like any purchase, the price is negotiable. In the final part of this masterclass, we are going to teach you the art of the exit. We will walk through a standard severance agreement line by line. We will show you how to negotiate a neutral reference, so your old boss can't badmouth you. And we will answer the ultimate question: when should you refuse the money and take them to court? The masterclass concludes next. You do not want to sign anything until you watch part 10. This is the final transaction. You are sitting at your kitchen table. The cardboard box with your desk plant and your coffee mug is on the floor. In front of you is a stapled document titled Separation and General Release Agreement. The company has offered you $10,000, which equals 4 weeks of pay, to sign it. You are scared about paying rent next month. Your instinct is to grab a pen, sign the line, and deposit the check immediately. Stop. Put the pen down. That document is not a receipt for a gift. It is a sales contract. You are the seller, and the product you are selling is your civil rights. Specifically, you are selling your right to sue them for every single legal violation we have discussed in the last 9 parts of this masterclass. Once you sign that paper, the exempt versus non-exempt misclassification lawsuit? Gone. The hostile work environment claim? Gone. The FMLA retaliation case? Gone. You need to understand the anatomy of a general release. It is designed to be comprehensive. It will list virtually every federal law in existence, Title VII, the ADA, the FLSA, the ADEA, and ask you to waive claims under all of them. This is standard. However, the price they are paying for that waiver is often calculated based on the assumption that you are ignorant. They are offering you the standard package. But if you know you have a viable claim, if you have documented proof of discrimination or wage theft, that waiver is worth a lot more than $10,000. This is where the leverage pivot happens. You do not negotiate severance by begging or talking about your bills. You negotiate by calmly highlighting the liability they are buying. If you can credibly signal that you are aware of a compliance issue, the company's risk calculation changes. It becomes cheaper to pay you $20,000 to go away quietly than to spend $50,000 defending a lawsuit they might lose. But there is a specific clock you need to watch if you are over 40. Under the Older Workers Benefit Protection Act, OWBPA, which is part of the ADEA, Congress decided that older workers needed extra protection against being bullied into signing waivers. If you are 40 or older, the law mandates that you must be given at least 21 days to consider the agreement. You cannot be forced to sign on the spot. If they say, "Sign this before you leave the room or the offer is off," they are likely violating federal law. Furthermore, after you sign, you have a mandatory 7-day revocation period where you can change your mind, undo the deal, and give the money back. If the agreement does not specifically mention these rights, the waiver of age discrimination claims might be legally void, meaning you could potentially keep the money and still sue them for age discrimination. Now let's look at the non-disparagement clause. Historically, companies included broad language saying you could never say anything negative about the company, its products, or its officers forever. They wanted to buy your silence. However, you need to know about the seismic shift that occurred in 2023 with the NLRB's McLaren-McComb decision. The National Labor Relations Board ruled that overly broad non-disparagement and confidentiality clauses in severance agreements are illegal because they prevent workers from exercising their rights to discuss working conditions. If your agreement says you can't tell your former coworkers about the unsafe conditions that led to your firing, that clause might be unenforceable. While you are reviewing the contract, you must look for the neutral reference provision. This is critical for your future. Most people assume that if a future employer calls your old boss, the old boss is legally allowed to say, "He was terrible, lazy, and smelled like soup." Legally, in most states, truth is a defense. If you were lazy, they can say you were lazy. However, most large corporations have a policy of name, rank, and serial number. They will only confirm your dates of employment and your job title. They do this to avoid defamation lawsuits. But small businesses are wild cards. A petty manager can torch your reputation with a single phone call. This is why you negotiate for a binding neutral reference clause in your severance package. It should state, in response to inquiries, the company will only confirm dates of employment and position held. You want this in writing. It turns a verbal risk into a breach of contract issue. Let's talk about the money you are owed versus the money they are offering. Severance is extra money. Final pay is earned money. They are not the same. Federal law does not require immediate payment of final wages. It defers to state law. If you are in California and you are fired, your final paycheck, including all earned wages and accrued vacation, must be handed to you on your last day. If they mail it to you and it arrives 5 days later, they owe you a waiting time penalty equal to your daily wage for every day it is late, up to 30 days. That could be thousands of dollars in penalties for a simple administrative delay. In other states, they might have until the next regularly scheduled payday, which could be 2 weeks away. You must also check your state's laws on accrued PTO. In states like California, Colorado, and Illinois, earned vacation time is considered wages. They must pay it out. In other states, if the company policy says use it or lose it, and you quit with 100 hours of vacation saved up, that money vanishes into thin air. Then there is the safety net, unemployment insurance, UI. This is a state-run insurance program funded by employer taxes. The general rule is, if you lose your job through no fault of your own, layoff, RIF, business closure, you get benefits. If you are fired for misconduct, you do not. But misconduct is a high bar. Being bad at your job is usually not misconduct. Misconduct is stealing, fighting, or chronic absenteeism after warnings. If your boss fires you for poor performance and tries to block your unemployment claim, appeal it. You will likely win. The burden of proof is on the employer to prove you were malicious, not just incompetent. However, be careful with resignation. If you quit, you generally forfeit unemployment. The exception is constructive discharge. This is where you argue, "I didn't really quit. The working conditions were so intolerable, illegal harassment, safety hazards, wage theft, that a reasonable person would have felt compelled to leave." This is hard to prove. You usually need a paper trail showing you reported the issues and the company did nothing. One final negotiation point. COBRA. When you leave, you lose your health insurance. COBRA is a federal law that lets you stay on the company plan for 18 months, but you have to pay the full premium, both your share and the share the company used to pay, plus a 2% admin fee. It is shockingly expensive. In your severance negotiation, ask for COBRA subsidy. Ask them to pay the premiums for the first 3 or 6 months. It is a common concession that saves you thousands. So when do you sue? This is the ultimate question. Litigation is slow, public, stressful, and expensive. A lawsuit can take 2 to 3 years. Your name will be in public court filings, which future employers can search. You generally sue when the damages are catastrophic and the evidence is overwhelming. If you were fired for having cancer, ADA violation, and you have the emails proving it and you have lost a $150,000 salary, that is a case for a lawyer. If you were fired because your boss is a jerk and you lost $5,000 in wages, the cost of the lawyer might exceed the payout. In that case, filing a free complaint with the EOC or the Department of Labor is the strategic move. It triggers a federal investigation without costing you a dime in legal fees. We have reached the end of the road. We have dismantled the myths. We have looked at the at-will doctrine, the discrimination traps, the overtime scams, the safety laws, and the digital surveillance state. You now possess a framework. You are no longer the employee who nods blindly when HR slides a paper across the desk. You are an informed participant in the economy. You understand that employment is a contract, not a family. You understand that HR protects the company, not you. You understand that your rights are not self-enforcing. They require your vigilance, your documentation, and your courage to exercise them. Take this knowledge, verify it against your specific state laws, build your file, save your money, and walk into your workplace tomorrow with your head high, not because you are arrogant, but because you are competent. The system is designed to be complex, but it is not impenetrable. You have the map now. Thank you for watching this masterclass on basic employee rights. Now go get paid what you are worth.